A warm welcome from the heart of Munich at the Café. The European Data Protection Board, abbreviated as EDPB, has addressed the so-called pay or OK model at the behest of individual national supervisory authorities, which the Meta Group has particularly switched to for its products in Europe. What this is all about and the direction it has taken, more on that in today's video. Briefly, what is the pay or OK model? It is the option for the user of a platform, here for example, can choose on Facebook or Instagram in Europe whether they agree to the free version, which then also displays personalized advertising, or alternatively agree to a paid subscription to use the platform without this personalized advertising. The whole issue stems from a years-long dispute, particularly with Facebook Meta, regarding the legal basis on which the Meta Corporation is allowed to use behavioral targeting, i.e., personalized advertising to users. They initially chose the legal basis of contract performance, then switched to the legal basis of legitimate interest after the CJEU overturned it. Now the CJEU has also overturned the legal basis of legitimate interest for Meta, and the pay or OK model, i.e., consent as the legal basis, has been adopted. However, it is by no means the case that only Meta would use this model. Many media outlets, especially in Germany, also use the pay or OK model for their own platforms. The task now facing the EDPB was that if the pay or OK model is deemed legally inadmissible under data protection law, it would not only harm Meta, but also put many media publishers in a difficult position. However, if the pay or OK model is approved, there is a risk that data protection as a fundamental right will become a commodity, a tradable good, and ultimately the regulations of the GDPR could be undermined altogether. The EDPB, European Data Protection Board, has now in a so-called opinion, that is, a statement of opinion, without explicitly mentioning Meta or Facebook, stated that the EDPB, European Data Protection Board, has introduced the new concept of so-called large online platforms, and further mentioned that, simply put, behavioral advertising is inadmissible for these large online platforms, particularly for two reasons. The affected individuals do not even know what they are transparently consenting to. Secondly, the voluntariness of consent is not guaranteed on large online platforms, as the social pressure to join them, because so many people use them, is so high that there is no situation of voluntary consent. This, therefore, shortens the practical application of the paper. Large online platforms like Meta are not allowed to conduct behavioral advertising on the PIOC model. Smaller or medium-sized media houses, on the other hand, are still allowed to use the pay or OK model. You can definitely imagine that the reactions to this are highly more than divided. On one side, we see many representatives celebrating this opinion as the salvation of the GDPR, emphasizing that data protection does not become a commodity, and that the GDPR cannot simply be circumvented by this model. On the other hand, you see very harsh criticism, particularly from the business sector, but also from some voices within the supervisory authorities who say that this is, firstly, an inadmissible interference with personal autonomy, and, secondly, that in smaller or medium-sized media houses, those affected often do not know what they are consenting to. And ultimately, by redefining large online platforms, the EDPB, European Data Protection Board, is clearly exceeding its competence, essentially engaging in judicial activism and going beyond the wording of the GDPR, General Data Protection Regulation. What happens next? Firstly, the decision of the EDPB itself, being formulated as an opinion and not explicitly mentioning Meta and Facebook, cannot be directly challenged by Meta at the CJEU under the current jurisprudence. another topic. Nevertheless, it is naturally relevant that the decisions of the EDPB, European Data Protection Board, generally do not allow for direct legal protection. How will the whole process likely proceed now in 2021? The lead supervision regarding Meta lies in Ireland. Ireland does not have to share this opinion. However, if it does not, there is the possibility of making a binding decision through the EDPB even against the will of the Irish Supervisory Authority, effectively forcing Ireland to base this legal opinion in the proceedings against Meta. If such a decision were to be made, tenants would have the option to take legal action against it, that is, to pursue legal recourse in Ireland. And this, in turn, could lead to this legal question being presented to the CJEU, Court of Justice of the European Union. It is therefore expected that this issue will ultimately end up before the CJEU, Court of Justice of the European Union. To close with a well-known quote, "Indeed, no one can serve two masters." The EDPB, European Data Protection Board, is attempting to strike a balance by allowing media companies to maintain their economic basis with the pay or OK model, while at the same time taking away the same model from large online platforms like Meta. Whether this is permissible under data protection law, in the manner pursued, will ultimately be clarified by the CJEU. What else has happened? The Regional Court of Hamburg has ruled that online shops are not required to provide a guest access option. Here too, the supervisory authorities had taken a different position. The decision is not yet legally binding. Link in the description. Enjoy reading.